Great. So we'll get started, even though I suspect that more people will be joining over the next few minutes. My name is Jerry Bonavia. I'm the Executive Director of WAVE Educational Fund. We're here tonight to talk about the Supreme Court's decision. And I guess to start with, we're not terribly surprised by the decision. After hearing oral arguments at the end of last year, it seemed like this was probably the direction that the Supreme Court was going to go. And still, as I read through the decision today, I was crushed. I think in middle school, I learned that, among others, one of the functions of government was to honor and, through the courts, protect our individual rights. But I could have sworn that they were also tasked with honoring and protecting our collective rights, our collective well-being. We are, after all, living in a society. Yet I was struck when reading this decision, particularly the opinion of the majority, about the lack of concern or even acknowledgement about the devastation that we as individuals and as a society are suffering because of gun violence. We cannot go to a movie theater or a concert or a grocery store. We cannot send our children or our grandchildren to school without thinking about, without worrying about gun violence. And yet I saw none of that reflected in the opinion today. So I am disgusted and I have questions. And luckily we are being joined tonight by someone who can help us work through what was in that decision and what it will likely mean for all of us. So I want to welcome my good friend, the Vice President of our Board of Directors and former U.S. Attorney, Jim Santelle. Jim?
Jerry, thank you so very much for inviting me with you this evening. It is a momentous day in the history of America, as you just indicated. And tonight we gather together to follow up on your stirring and very important comments about where we are tonight and where we go from here. We have had a major decision today, and tonight's discussion is going to be, as Jerry just said, all about what that decision says, what it doesn't say, and then some commissions for the future, the things we can take forward and know that our fight to ensure safety and security, as Jerry just described it, is not over and is not coming to an end today. So let's jump into the focus of today's Supreme Court decision. And for that purpose, as I'm just confronting a little bit of a movement issue here, there we go. We're going to start with specifically the kinds of devastation statistics that Jerry just talked about. I don't need to tell anyone gathered here with us tonight about these kinds of stunning statistics. The number of firearms related homicides in 2020, which is the most recent calculation of those coming out of the Centers for Disease Control and Prevention. The total firearms related deaths in 2020, well in excess of 45,000 altogether, and the toll that these kinds of activities, the impact that firearms have had, especially on our communities of color. This information is especially relevant because, as you're going to see in just a few moments, one of our Supreme Court justices today invoked precisely this information in making the point that Jerry just made, which is the Constitution needs to be living, it needs to protect us today, and this information is relevant. So let's talk about more of that. We also know that as of today, there have been well over 7,300 interpersonal deaths in America, not including those specific categories related to firearms. And we also know all too painfully, whether it is in Uvalde, whether it's in Buffalo, or many other places throughout our nation, including right here in the Midwest and Wisconsin, the number of mass shootings to date. There you see the numbers. There you see the impact of this pandemic, this disaster, this crisis, this cancer that we have in America related to guns. And so it's in that setting that, as Jerry just said, we gather together tonight to talk about this monumental landmark case decided just this morning by the United States Supreme Court that has a direct impact upon all of us in a community, even as we are also individuals. And we start then with the Second Amendment itself. Very important for today's discussion to understand and digest once again precisely what the language of that text is, because as you're going to see, the Supreme Court in its majority opinion relies principally on text and on history. The history at the time this was written and ratified by the states, the text authored by people like James Madison, George Mason, and as the dissents will tell you, as you're going to hear in just a few moments, a text in the history that still has to be living, that has to be understood in the context of what we are in fact facing today when it comes to firearms violence and the horrific impact it's having on our lives and our livelihoods. And so let's begin with a little bit of history from 14 years ago. Many of you already know this well. This is the Heller decision. And we begin with this fundamental notion that for 200 years, since the time of the founders, since the time of the passage of the Second Amendment, the Supreme Court has specifically rejected the notion on 4 different occasions that there was an individual personal right to gun ownership in America. Instead, they focused on that militia language as the meaning of the Second Amendment as it was understood historically, and then also in terms of its present understanding. And it was only in the 1970s and into the 80s and then into our recent times that there began to be some review of that issue. And sure enough, it came out of the District of Columbia way back in 1975 because of a huge violence issue there, which continues in many cities to this day, as we unfortunately know. The District of Columbia legislators passed a law that says that when it comes to firearms possession, you cannot hold one, you cannot possess one, especially in your home, or it's got to be disassembled. And the reason for that was a connection between governmental action, what Jerry was just talking about to keep us safe and secure, and legislative actions to ensure that that security is promoted. And so for many, many years in the District of Columbia, that was the law. And at some point, after living and working under that regime effectively, that structure in the District of Columbia for many years, this gentleman named Dick Heller decided to challenge it and said, you know what? I think that's wrong. I think under the Second Amendment, I'm going to contest 200 years of history, and I'm going to bring this to the Supreme Court about whether or not I have an individual right in the District of Columbia to own a firearm in my home, contrary to what the legislature had done to keep him and others safe and secure. And sure enough, it went up to the United States Supreme Court. And 14 years ago, June 26, 2008, almost 14 years ago, the United States Supreme Court, by a 5-4 majority, a different court at that time, but not a unanimous opinion, by a 5-4 majority, authored by this man, who is Antonin Scalia, no longer on the Supreme Court, as you well know. Justice Scalia, on behalf of that majority, issued this opinion in Heller, and basically, for the first time in our history, said that there does indeed exist inside the language, the text, and yes, he went back to the history of the Second Amendment and said there exists a right to personal gun ownership in the home for traditional purposes, namely self-defense. Significant change with respect to the entire arc of history to that time, and that remains good law to this morning and even to this day, significantly. Again, also for today's opinion, look at that other language that Justice Scalia incorporated principally into his opinion 14 years ago. Nothing about that decision in Heller establishing a personal right, an individual right to gun ownership under the Second Amendment prohibits, in fact, even contemplates that legislatures and government officials will act to keep us safe and secure, that controls and restrictions and regulations, even prohibitions on guns related to all kinds of places, all kinds of transportation, manufacture, sale, all those kinds of things are in fact legitimate and constitutional. That was Heller 14 years ago, and Heller remains good law to this day. There was another case called McDonald versus Chicago a couple of years later that extended Heller to all the states. And so that also is good law to this day. And it is in the wake of that then we get to this morning's case. There is a long-standing concept out there, and we have it in the state of Wisconsin. Virtually every state has some process by which, if you want to carry a weapon outside of your home, in public, in these so-called secure places, you have to get permission, okay? And in the state of New York, there is a specific policy, a practice that before we can authorize you to conceal carry your weapon, you need to file an application, and you need to show to us, because of our interest in securing the safety and security of our population, that there's something about your situation that makes you special, that makes you maybe not unique, but that makes you different from everyone else in terms of employment, where you live, where you work, that justifies your need, your specialized need for a weapon. And that has been, until this morning, the law in the state of New York and a handful of other states that have this same kind of discretionary review with respect to the legitimacy of that kind of application. So the question is, does the Heller principle that establishes your right to gun ownership in the home, does it now leave the home and go into public settings? Do you have a constitutional right to carry a weapon, concealed, otherwise, in public under the Second Amendment to the Constitution? And we know from this morning's opinion, just decided today by a 6-3 vote, we'll get to that in just a moment or so, that indeed New York's law found unconstitutional, that government could not, at least under this kind of a regime, establish that kind of prerequisite to getting a concealed carry, an open carry, if you will, also permit to carry a weapon. It's described as the proper cause. In other words, what is your reason for, what is your cause for asking for and perhaps getting this special permission to carry a weapon that others, maybe similarly situated, do not have? And the Supreme Court this morning, a few hours ago, found that indeed under the Constitution, there is that right that goes from the home into the public for all ordinary abiding citizens for self-defense needs to carry a weapon in the public domain. And so that the amendment itself, incredibly important, the amendment itself kind of self-effectuating, the very text of it, as we're going to see, establishes inside that language the balancing test that up to now, New York and other places, was done by legislatures. That's how significant this finding and this opinion is today. And so this is the Justice, Clarence Thomas, who authored this opinion this morning. It is very lengthy. It is worth a read, as are the dissents and the concurrences, joined in by Justice Thomas, Chief Justice Roberts, Justices Alito, Gorsuch, Kavanaugh, and Barrett. And there, once again, you see this basic affirmation based upon Heller, moving from the home into the public. And again, the right to carry a weapon for self-defense. It is not a second-class right, the justice's right. And it is, in fact, not premised upon a specialized need that you've got to show the government, as you would otherwise until this morning in New York, and probably going ahead down the road. And again, this real strong affirmation about the notion that the Second Amendment, by its text, and then also very significantly by its history, a history analysis to determine whether or not a right under the Constitution continues to exist. Justices Thomas and the others go into great length, reviewing once again, as did Justice Scalia 14 years ago, the predicates, the historical predicates that they found leads to this conclusion today. And so they're all the Supreme Court justices. They're all smiling in that picture. But as you're going to see, not all of them are happy about this majority opinion. There's additional language. And again, establishing that this home-public distinction that may have existed up until this morning between home and public ownership no longer exists, that the right to own a weapon in public is just as strong in public as it is in the home. And the confrontation, which can happen outside of the home, does happen outside of the home, also carries with it this fundamental carry concept. And so that language also from the opinion this morning of the United States Supreme Court by a 6-3 vote. We have some very important concurrences, that is, two justices who join in the majority opinion, who nonetheless write separately to tell us more about what this case means. And this is significant because it also indicates what we're going to be thinking about in the future. And it's in the majority opinion authored by Justice Thomas, but it's also here as well. There are the may issue regimens, as they're described. This is New York, where there's a discretionary decision made by government officials assessing the merits of your particular need. And it's those regimes, if you will, that the Supreme Court is specifically tamping down today. And then also says that those that have a must issue approach, where there are some administrative, maybe even ministerial requirements about an application, some training, maybe a fees, those are separate from this, and those will continue. And so that's a significant, important distinction, even inside this very broad and frankly, still very concerning articulation of the broadening of Second Amendment concepts. And the other point that's very important when it comes to these concurrences by Justices Kavanaugh and the Chief Justice Roberts is this. They reincorporate very explicitly in the final page of their concurrence all of the Heller language. Nothing about this opinion today affects the capacity, the ability, the prerogatives legislatively for government to do the kinds of things that Jerry talked about, which is keep us safe and secure by passing laws that do in fact keep our security in place with respect to manufacture, sale, transfer, all the use, the methods of keeping a firearm, all those things in Heller that Justice Scalia said can in fact be done by government, those still exist. And there's no reason why there's anything about today's case that undermines that fundamental notion. We've got two other concurrences. Again, these are separate concurrences, also joining the majority, but they also underscore some very important points here. You see Justice Alito there on the left. He also affirms this fundamental notion that nothing about this opinion should be interpreted to mean that these restrictions, the conditions, the prohibitions that we've talked about are in any way forbidden. Very important. And he goes on also to begin to spar with Justice Breyer in a major way. And he does in fact say that history is everything and text is everything. And as you're going to see in just a moment, Justice Breyer's focus on ensuring that the government action is related to what's happening today, kind of a means test, a means ends test as they describe it. Does government have a legitimate purpose in imposing a regulation to keep it safe? Justice Alito spars with Justice Breyer on that and says, no, history is everything, text is everything, and Justice Breyer, Justice Alito says, is wrong. And then we also have Justice Amy Coney Barrett also noting that there are some historical limits on what the Supreme Court is doing here today. But again, concurrences in the main opinion. And then we get to these stunning and very, very important dissents. And they are issued principally by Justice Breyer, who writes for him and for two other of his colleagues, Justice Sotomayor and Justice Kagan. And again, commend very much to your attention and your reading those two opinions as well. The opinion from Justice Breyer joined into by those two other justices. And he goes back to the very first things that Jerry and I talked about. He cites actually the CDC information, the information about what's going on in America today and the crisis that we have, the challenge that we have, and says a Supreme Court lives in the present. And yes, he acknowledges history, and yes, he acknowledges text, but says the Supreme Court is necessarily a body that looks to the entire Constitution, and yes, it is a living Constitution. And it is wrong, he says, for the majority, including Justice Alito and most principally the other justices on the Supreme Court, Justice Thomas and his colleagues, to not consider the deadly consequences of today's decision. That's a stunning thing for a justice to say, and yet there it is at the end of his opinion. And then here it is where he gets a bit legal, but all of us can understand this. He says, you know what? Government does, in fact, have a means and approach to things. What means are you taking to achieve the end of security and safety? And if the end is legitimate to keep us all safe and secure, the means probably will survive the scrutiny given that by a judge, even by legislative counsel, by others in government who are looking to see if there's a rational connection between what the government is doing and that end of keeping us safe and secure. And he says that the explicit rejection by Justice Thomas and by Justice Alito, with whom he is sparring, that rejection of them by that contemporary analysis is simply wrong. And I'll let you read that final bullet point there. This is certainly tongue-in-cheek, but it makes the point compellingly. He says, you know what? All these things that you look to, things related to the colonies, the founding fathers, the 19th century, the postbellum period, the 20th century, those are all interesting. But as you see there, the things that you would see in a Renaissance fair today, They're not especially helpful in understanding the weapons that are used today, the things that James Madison and George Mason never could have contemplated. And for that reason, this exclusive focus on history and text is simply wrong. And again, as I said, he's joined in that opinion by two other justices. There they are, Justice Sotomayor and Justice Kagan. And they also, again, joining with Justice Breyer in this language. That same history that the Supreme Court looks to, that same history also says that you can, in fact, restrict, impose obligations, and impose conditions on all of those things. There is no uncertainty about that under Heller and today, and also rejecting this very narrow approach that the Supreme Court takes today in establishing, broadening this constitutional right under the Second Amendment. And there, once again, as you see in that last bullet point, this all-important focus on means ends testing. And again, that's your legal instruction or tutorial for tonight. That's simply highfalutin language, if you will, for saying, what should government do? And isn't it appropriate for courts to apply some scrutiny, to take a look at that analysis, to take a look at what the other states, including New York, have done, and determine whether or not New York's intent in asking people why it is they want to have a gun in public, why is it that you need that gun, that end of security and safety, whether you are in Manhattan or Albany or Buffalo or other places in New York, that's legitimate. That's legitimate. And they're saying that today, by virtually restricting and completely obscuring, if not discarding completely, that kind of test, we have gone astray. And so that is a very, very quick, but nonetheless, and not completely exhaustive review of the opinions today. They're well over 160 pages altogether. And I commend, as does Wade generally, and Jerry and all the members of the board, all of us here today, your reading of it. It is accessible, and I encourage you to do that tonight. The big takeaways are this. As Jerry said, is this an opinion that goes, from my perspective and the perspective of many others, in the wrong direction? Yes, it is. Is it premised upon the 200 years of history that this country has understood the Second Amendment to be all about? It is not. And although we've gone down this road since Justice Scalia in 2008, this expansion makes us less safe and makes us less secure, and doesn't permit the kinds of things that New York wanted to do to keep its people safe and secure. There are, as I say, there's important distinctions between the kinds of authorizations and permits. These may issue and must issue, shall issue permits. And at the same time, on a higher and more important note for all of us affiliated with Wade and this general movement toward keeping us safer and more secure, here are the things that the Supreme Court today does not implicate, does not affect, does not restrict. And you see them all there, the things that Wade and Jerry and members of the board and all the staff and all of you have also been advocating for. Nothing about the opinion today, although it does expand Second Amendment rights in a way that is, to my mind, disturbing and concerning, and may in fact be revisited by a future Supreme Court. Nonetheless, all the advocacy that we pursue today with respect to what? Universal background checks. Why? Because they keep us safer, ensuring that people who shouldn't have guns don't have guns. ERPOs, to ensure that people who are even temporarily should not be carrying and using weapons and jeopardizing their own safety and those of others, going to a judge and saying, for a limited period of time, this person should not have a gun. Make that determination, Your Honor. That kind of thing can keep us more safe and more secure. Safe and secure storage in the homes and other places. We know that those kinds of things work. We know that bans on semi-automatic weapons and other high-capacity magazines, they work too, because they worked in America in the past when those bans were in place. And we know that those things, if they're re-implemented today, which they still can be, even under Bruen, even under Heller, that those things can make us safe and secure. And then very broadly, all the support that WAVE and other entities do to ensure that there is firearms enforcement in a way that is reasonable and balanced, and that we have violence protection and intervention initiatives that likewise are focused on what? The legitimate purpose of government and all of us in the private sector, in the public sector, to keep us more safe and more secure. All of those things are not affected today. Will there be those attempts tonight, probably underway even as we speak, to take this very broad language that we just talked about under the decision in Bruen and make it broader? Will the lawyers, will those people who want to make this even more strong and more broad than it is already, are you going to see litigation? Absolutely. And that's why the fight must continue. And that's why, even though today's decision, as Jerry said, not unexpected, still shocking, even though it is out there, that challenge, that fight to ensure that those people who may seize upon this language from the Supreme Court, from Justice Roberts, from Justice Alito and others, that effort should not be broadened even more, to take it beyond what it is today in states around the country, including New York, including Wisconsin, and that's where the fight needs to continue, even as it is taken up today. And so with that, I encourage you now to raise questions, comments, observations. I am so happy to be joined not only by Jerry tonight, but also by my colleague and friend Nick on the staff, who is going to chat with me and chat with you about questions, comments that you may have, things that I did not cover completely, implications of today's opinion that Nick and I and Jerry can further answer for you tonight. This is now the question and answer period, and we very, very much welcome your thoughts and your questions in the final half an hour or so of our time together tonight. And I thank you very much for participating with us in this, and again, look forward to your engagement now with all of us.
Thanks, Jim, and welcome to everyone. Thank you for joining us. As Jim said, my name is Nick, and along with being the Policy and Strategic Partnerships Associate at WAVE, I'm also a licensed attorney, so I'm happy to maybe help out answering some of your questions. So the way we're going to do this is, if you have any questions, feel free to either raise your hand by using the hand raising function on Zoom. If you're not familiar with that, you'll look at the bottom of your screen, go to reactions, and there'll be a button there that you can press to raise your hand. But please do note that this conversation is being recorded. So if you're not comfortable speaking on a recorded video, that's understandable. In which case, the other option is to put your question in the chat and I can read it out loud for you. But while you're thinking of your questions and formulating those great questions, I'll go ahead, Jim, and ask a couple of questions that I had thought of beforehand. So just to start, after today's opinion in Bruen, what gun regulations would you say are most under threat? And are there any current laws on the books that might be hard to pass under this new text, history, and tradition test that the court put out today?
Right. And so, very consistent with what my final remarks were, we can anticipate that this very broad language that was in some of the slides, Nick, at the very start of this presentation, there are the lawyers like you and me and others out there who are going to seize upon that. And even though the language of that specific text in the Supreme Court today in Bruen really does not support the end, they're going to say this, that because the Supreme Court's trend 14 years ago and again this morning is in the direction of increasing gun rights, increasing access to it, increasing the capacity of human beings and Americans in every state to use guns, not just in the home, but also in the public, that should animate and that should infiltrate every other consideration that is out there. So one answer to your question would be, and this is what lies, all of the advocacy of all of us tonight is so very important, is to ensure that as those kinds of arguments are made, we are clear about what Bruen says and what it doesn't say, and that we can invoke, frankly, the context that Justice Alito and Justice Coney Barrett and others specifically invoked to say we are pushing back on all of that. But when it comes to the specific things that are out there, as I said, the issues related to firearms, universal background checks, those kinds of things should not be implicated by this. Other things related to safety and security, outright bans on guns, that's different. That's different from the place in which you can carry these particular weapons. And the other comment that I will make, which we didn't chat about a lot, and hopefully in response to your question, Nick, is just this. I think all of us were anticipating, based upon the oral argument that Jerry just described from last fall, the case would go this way. There was a whole lot more focus upon places where you can, in fact, carry weapons outside of the home. secure venues, secure places. And there are some references to that in the majority opinion and certainly in the other opinions as well, but not nearly as much as I thought. And there was actually a reference to Manhattan as being a place where that may not be a secure place just because there are a lot of human beings there and the New York Police Department is enforcing the law there. And so one of the areas where there will be pushback and there will be analysis and will be litigation about what are those places outside of the home where now under Bruen, I can, as a citizen, properly take my weapon. And are those schools? Are those hospitals? Are there government buildings? How broad is Heller and how broad is Bruen in identifying what that category of places that can in fact prohibit you from taking your guns? What about shopping malls? What about places, what theaters and sports venues? All those places where large people congregate. Supreme Court did not give us a lot of direction on that tonight, this morning. And that's where I think under this particular case, a lot of the fight will now be. And there will be those people who are say the language of the majority opinion is broad enough to make those secure places either small in definition or small in number.
Would it be fair to summarize kind of the holding from today's ruling to say that most directly and really only directly impacted by this ruling are the 6 states that have the may issue regimes and not the states that have shall issue or something along those lines?
I think that's exactly right. It's an important thing to know. Again, this broad language, but both the majority opinion and yes, indeed, the concurring opinions, especially that from Justice Kavanaugh and the Chief Justice, are very, very quick to say, do not think that every state's authorization permitting process, including that here in Wisconsin, is now unconstitutional. New York may well have to go back and rejigger its processes and put those together again. But in most places, again, Nick, you got it just right, the language where you have may issue discretionary decisions made by government officials like New York, determining whether there's a special need particularized to you. That's different. It exists in about 7 states or so. 43 states, as the majority says, do not have that, and they have the shall issues. And those are for those states where you can get a concealed carry permit by doing the ministerial and process things that need to be done and doesn't have an impact on those, once again, tempered by this very broad language by the Supreme Court that we may see invoked in even addressing and perhaps even attacking those other 43 states. We don't know what that's going to look like yet, but there is something in the language here of the majority to even pursue that further, right? And that's the concern about tonight's language and today's opinion.
So I have a question in the chat as well, asking if we could kind of explain a little more about how this impacts open carry versus concealed carry. Is there a difference in how this ruling is applied to those 2 different concepts?
Sure. My sense is, again, I will tell you, I will confess that I am not an absolute expert in those processes, certainly not in every single state. But you look to the particular provisions in the state in which you live, and they're accessible. We have a Department of Justice that issues these here in Wisconsin, and there are provisions, obviously, that permit concealed carry, and the circumstances of that are set forth with great regularity. It is still necessary to comply with all of those regulations before you can, in fact, get authorization to carry weapons under either of those categories. And so every state is somewhat different. The Supreme Court did not delve deeply into that today.
So I can add a little bit to that, and then I also have a question. So open carry is not regulated in Wisconsin. It's not regulated in many states. So it is something that's concerning that because there isn't that historical precedent, I don't know if this means that it would likely be challenged for a state to try at this point to do further regulation of gun carrying. I just don't know what's going to happen because of that. My quick question is, as they talked about sensitive places, I know they didn't attempt to give an exhaustive list, but did they happen to mention courthouses, like, where Justice Thomas works?
Right. absolutely. And so a lot of the language, and the answer is yes, that you can find specific reference to government buildings, which of course include courthouses. And there's some examples of those sensitive places, but Jerry, you got it just right. I think that in addition to attempts to broaden this language into areas where there have not previously existed, that is going to be the next fight, including tonight, tomorrow. What right here in Wisconsin or in other places, what are those places? And it's difficult to imagine that at some point, the United States Supreme Court and lower courts, including district courts here in Wisconsin, the Federal Appeals Court in Chicago, are not going to have to wrestle with that and say, okay, if we say that a courthouse is a secure place and you can put a sign up that says no guns, no entry, what does that mean for the government building right next door? Well, maybe that's also okay. But what about the school? What about the social services agency that's right down the street? All these kinds of places that support human beings, where people gather and congregate. And again, it goes into academic areas. What about recreational places? If you think about it, it's difficult to imagine, especially as you said at the outset, where we live in America, where we go. We are, yes, we're often alone in our homes, other places. We take walks, we take hikes. But think about all the places where we do in fact congregate, and where our collective security and safety is all important. And from my own perspective, my view is that the number of secure and safe places that should in fact be protected from, if you will, the ambit of today's opinion is much greater than the sidewalks and the narrow places, because we congregate together as a community, right? And the Supreme Court did not specifically address that today. I think they'll have to do that, and the courts will have to do that, probably beginning with cases being filed tonight and tomorrow morning.
Jerry, did you have a follow-up question, or was that,
Yeah, I'll hold on to it for a minute so that others can jump in.
Nancy, I see your hand is raised. Would you like to unmute and ask your question? Might have been, was that an accidental?
No, I had to have permission to unmute. So my question is, does this have any, this is just saying what the government where the government can say that weapons aren't allowed, but let's say at my faith community, if we wanted to say no weapons are allowed, is that still, I mean, would that hold any water, or would there be any, does that do anything if we just put a sign up, or is someone still allowed to bring their weapon to church?
And that is the all important question, right, Nancy, going forward, is how broad you interpret this. And you've, I think, identified another fundamental issue here. Obviously, all the Bill of Rights, including the Second Amendment, speak about government action, right? And government official capacity kinds of things. And in talking about the capacity of them not only to restrict, but also make laws in contemplating that people can in fact congregate. My own view is that under this, again, this is the reason for litigation probably down the road, under this sort of secure spaces and secure places doctrine that they have not exposed and not discussed in great length. Nonetheless, it is there and has been identified. I think that private institutions, quasi-public institutions can in fact do that. And I hate to say it, but challenged when someone says, I would like to bring into a meeting at your wonderful community gathering my gun, and I've got a right under Bruen to do it. And one of you says, we are making the decision under Bruen, and the concurrences there that we've got conditions that we can impose upon this. We've got restrictions about place and kinds of weapons. We're going to exercise that language and impose that language to require you to mandate that you not bring your gun in. And the next thing you know, regrettably, you've got lawyers, and we're fighting that next issue. But my view is, and it's probably is jaundiced a bit by my view, that we have got to be able to secure our safety and security even in the midst of this. This should not be a concession that anyone can bring a gun anywhere. Justice Scalia said that very, very clearly from 14 years ago. That's what you embrace. And when you put up that sign, that's what you say to the people who want to bring guns in. It does not resolve the conflict right in that moment. And that's why this is also so troubling tonight, right? You would like to have more clarity from the United States Supreme Court. I think we'll get it. But in the meantime, you do what you need to do to keep yourself safe and secure. And you point to that good language in Heller and Bruen that says that the government can, in fact, government and I would say private institutions, quasi-private public institutions have the right to safety and security. We are doing that under the Second Amendment to the United States Constitution. It's an imperfect answer, I know, but I think it's what we now need to embrace and adopt going forward.
And just to follow up on that point, I also know that during the oral arguments, there was a lot of discussion over which areas are deemed sensitive, which aren't. They talked about college campuses, they did talk about churches, schools, and all that stuff. And really, this opinion doesn't really give us clear answers on a lot of that. So for those of us in this field pushing for gun regulations, just keep fighting, because there's still a lot of room left for us to maneuver. There's a question in the chat. It says, is there any way to find out if any of the decisions, policies, laws, things like that are made or decided because someone is getting financial gains? And is there any government entity that closely monitors that? Jim, do you want to speak to that?
Sure. So the question, I think, is, how is legislation made, right? Have we seen the sausage making, as it's sometimes referred to? What we know that in the United States Congress, even as we speak, the irony of today's opinion coming out today is the United States Senate, the United States House of Representatives perched to vote on admittedly a very modest package of things, but that's happening right across the parking lot from the Supreme Court. And so one of the questions, the question you've got in front of you is, if in fact whether that's that legislation, maybe that's not the focus of the question, but when there is legislation passed, how do we know what the motives and the purpose of passages of various restrictions and things that do give people broader liberties, if you will, under the Second Amendment to carry weapons? What is the motivation for that? And the answer is, of course, a number of different things. We elect people because we anticipate that they will bring to this all-important public service process the oath that they take to work on behalf of the people of America, their best resources, their intellect, their judgment, and that they would not be implicated or rather affected by money, their own privilege, their own sense of advantage in some way. That's our aspiration. And when you see someone engaging in behavior, as we have seen recently in the past, in self-dealing, legislative and otherwise, that's the time that you need to pursue that, not only call that out. That's when we start impeachment proceedings. That's when we call for people to resign because they've given up on their oath. That's also, if you find it to be corruptly motivated, that's frankly when federal and state prosecutors get involved for violation of the public trust that is placed in government officials. It is a very important question, especially going forward as we design more laws, if you will, about secure places. And even the wake of Bruen, what is next? What is the legislation? How can we even push this next big package of things beyond what the Congress is doing today? Gosh, we would like to have people making those decisions not premised upon campaign contributions, not premised upon the next election, not premised upon their own political animus, and yet we know that's happening. And that's the reason why folks, all of us, WAVE and the wonderful work that Jerry and Nancy and Nick and everyone does here, we've got to keep our elected officials honest and have to elect people, frankly, and get them in their appointed positions as well, who bring to it that independent discretion. They're there to enforce the law on behalf of what? The safety and security of all of us, and not be jaded by their own personal interest. It's not an easy thing to do, but that is a great challenge going forward.
I just want to flag too that Jerry put in the chat that there's an organization, not a government organization, but there is an organization called opensecrets.org that tracks financial contributions. And yeah, just to kind of expand on that, all financial contributions should, in theory, be public. If they're not, that under the table dealings that we don't know about. But yeah, so there are ways to find that website's one example. another question in the chat, just kind of asking, how can we follow the legal challenges to this rule or the expansion of the rule? So I think what the question is basically alluding to is when you have cases in like the lower federal courts challenging this and things like that, how can people stay engaged and follow all that?
It's a great question. And one of the things that you can do, obviously, this is a significant time in the history of our nation, not just for this, but that the United States Supreme Court is also going to be issuing, perhaps beginning tomorrow and into next week, as we all know, major cases on privacy rights and abortion, cases in the area of immigration and environment and religion. And they've got about 9 or so cases yet to decide. All of those, with respect to those cases, can be tracked by going on the United States Supreme Court website and taking a look at what cases have been decided. You can also go, obviously, one of the other things that I advocate for is going to a legitimate and reliable news source, right? And I realize that can be challenging today, but there are places like the New York Times and others, legitimate broadcast media that does follow and is as integrity in reporting, not only on those big cases out of the Supreme Court as they come forward, but also at the district court level, the federal district court level, what's happening in eastern Wisconsin, western Wisconsin, Milwaukee, Green Bay, and Madison. You can track that also to some extent on their websites, but also by reporting, by following up and looking at the local media, the print media, the electronic media as well. The Court of Appeals for the Seventh Circuit, where all the appeals from Indiana and Illinois and Wisconsin, all of those are funneled through the Chicago Court of Appeals in downtown Chicago. They also have a website, and you can see their decisions posted. Undeniably, as we just talked, Bruen is going to generate more of these kinds of cases, and they can be tracked again officially, but also through the media. And also good organizations of the sort that Jerry just identified, an awful lot of good non-public, quasi-private institutions that we are affiliated with, that others are affiliated with, that also will let you know if you're a subscriber, if you're a member, they'll let you know on a very particularized basis where those cases are and watching them very carefully and thoughtfully.
I'll also put in the chat, but there's a great website that I like to follow called SCOTUS blog. And that's kind of a fun way it's really written for anybody, that very accessible, and you can file just about any legal case that's pending at the Supreme Court or even lower courts as well. So another question, we've touched on the bill in the Senate a couple times, and that's obviously on a lot of people's minds, but Jim, you get the idea that any of the takeaways from the ruling today will affect any of the portions of that bill?
Right. As I understand what is coming out of this bipartisan group and proposing things on the floor of the Senate, and presumably going over to the House and perhaps making its way, very significant, to the president's desk at some time very, very soon. The first thing I would say, and I suspect Jerry and others and Nancy and all of us affiliated with WAVE would recognize that the very fact that the United States Congress is finally doing something, even with a small s, is significant in opening up that door, but also recognizing that that is a door that's just opened slightly. And those larger things we talked about at the very end of our formal presentation, those are the things we keep our eye on. And those are the big picture items as well. As I look at the things that the Senate and ultimately the House are looking at right now, I do not see any conflicts whatsoever with the, again, I will say the fairly modest, they're important, but they're modest movements in the right direction. Nothing, if someone says to you, oh, today the United States Supreme Court by Bruen shut down all firearms legislation, absolutely wrong. That cannot be the case. There's no justification for that whatsoever. It's just the opposite. And I don't see those particular things that are being advanced by the senators and obviously a majority of the House as well as being prohibited in any way but what we decided today. Nor do I see, to make the point once again, in those larger, very important issues, universal background checks, ERPOs, safety regulations, bans on semi-automatic weapons, safety regulations, initiatives for violence prevention, all of that goes ahead. And again, if anyone tells you that, gosh, today the United States Supreme Court told you you can't do those things, that is simply wrong. Not to say, once again, that we're not going to get those people out there who are going to tell you that and going to seize on some of the language from the majority opinion, but I would offer respectfully that those people are using the language inappropriately, inaccurately, and to deceive you into something that is not in fact the case.
Absolutely. I 100% agree. After reading through the case, I did not see anything that would put any of these regulations into question. So also want to flag for everyone in the chat, JC put a link there that you can contact your senators if you're from Wisconsin and the Wisconsin senators about the bill that's coming up soon for vote. Jerry, I realized we forgot to go back to your question. Did you still want to ask that?
Oh, no, yeah, that's absolutely fine. So I guess one of the things that was most concerning to me about the kind of new tests that the justices are suggesting we use for gun regulation is this historical look back, when in this particular case, as they applied that very theory, they picked and chose which points of history they were going to consider, and just kind of, offhandedly dismissed the very things they were saying they would need to see. So I was really concerned about that. The fact that New York had some kind of regulation about carrying for 100 years, they just kind of tossed that aside and said it had to be older. But then they looked at what Western territories had done and said, no, that's too old. That was before they were a state. So it's just kind of concerning that it seems like they can use the willy-nilly test to determine what part of history is going to shape what will be allowed and not allowed. Was that concerning to both of you as well?
I suspect Nick will join me in this as well. This what it's calling probably the new history/text test, which is exactly what you described it there. I like the phrase willy-nilly, and I also would say that a lot of that falls in the category, with due respect to all of the justices, it's intellectual dishonesty. It is picking and choosing, it's cherry picking. And if you want the best example of that at all, you can look at Heller from 14 years ago. You see Justice Scalia going back and doing a lot of the history. And then you see the members of the Supreme Court. The other four at the time was a different court at the time, including Justice Ginsburg and others, who say, no, that history is just wrong, or you have cherry picked it and we can come to a different result. The same thing happened this morning. You can look at Justice Thomas's opinion, talking about all these different areas, talking about the times of the colonies and the founding era and the 19th century and all these periods and up to the 20th century. And then Justice Breyer, in his very lengthy, but again, very accessible opinion himself, says, wait a minute. I can go back and look at those same categories. It's exactly what you just said, Jerry. I can look at those same, let's talk about the antebellum period. Let's talk about the colonial period. And I will find support for the notion that indeed there is not this expansive right. And it is, I would offer to you, I think, it is more compelling and it is much more intellectually honest than what the majority has done today. But it is a concern that you have justices, again, that are not only doing that cherry picking, but again, if I can get on my soapbox one more time, then I will let Nick comment on this as well. It's Justice Breyer saying the particular kinds of maces and things and tools and weapons of attack that I can't even pronounce. I had to go to the dictionary to find out what these things even were. And he's plainly being a little bit tongue-in-cheek in the middle of a very, very serious issue here. What he's saying is it's got to be a living constitution. And whether it was colonialists or people in the 20th century, which again is now 25, 30 years ago, the reality is that those things that animated judges at that time, those things that animated legislators, local, state, federal, they would not recognize, maybe in the 20th century they would, but they would not recognize us today. I often said James Madison, George Mason. You think about the things in their lives, trains, planes, lights, automobiles, all those kinds of things. You can go on and on. Refrigeration, the ways in which we have healthcare, education, outstanding principles set forth. But the notion is that the Constitution, if it's to mean anything to keep us alive and keep our nation in place, it has got to be living. It's got to be breathing. And that's your point, not only about looking back almost exclusively to history, but also looking, as Justice Breyer did, at the 2020 and 2022 statistics, the numbers of mass shootings that we've had just recently. Is that important? Of course it is. And we need to be thoughtful as jurists, not giving up our role in deciding what the law is and making decisions about what the compelling facts are, but we've got to be making decisions in the law, in the world that we're living in today. And so I embrace both the cherry-picking, willy-nilly approach that I don't embrace that, your assessment of it. I think it's exactly right. And also would say that the history exclusively and the reliance on that without a contemporary analysis leads us down exactly the wrong path. Nick, your thoughts on that?
I'll just say briefly, and I know we're going to try to close out, but not to get too complicated, but to make it even more untenable, there's been a lot of discussion whether or not we should be looking at the Constitution or the time the Constitution was written in 1791 or in 1868 when the 14th Amendment came about. All wishes to say this test does not work. One last thing, and there was a question in the chat that I'll just answer really quick because it's easily answered. There's a question that said, can anything be done by Congress to reverse this? My understanding is that from con law is that the only thing Congress can do to reverse a case by the Supreme Court is to basically ratify a new amendment to the Constitution. I could be wrong on that, but that's like the basic understanding. But with that, I'm going to pass it over to close this out. Yeah.
Well, I want to thank you both, Jim and Nick, and everyone who joined us here. I know that, some of the things were concerning that we talked about today. Overall, I want to reemphasize some really positive language also included in the decision. And more than that, we are on the verge of seeing the first legislation passed by Congress in decades. And even though it falls short of where exactly we want it to be, it is evidence that even the Republican legislators who have pushed back hard against any kind of gun regulation for years are able to participate in this. And so we want to bring that same kind of momentum back here to Wisconsin. We want to see the Congress go further, and that means all of us working together. So we look forward to continuing to work on this issue shoulder to shoulder with all of you, because given what gun violence does to our country, it is without a doubt absolutely necessary for us all to stay engaged. And again, I thank you so very much for being part of tonight.